The gavel has fallen, and the sound is echoing through the corridors of power in Washington and the halls of justice in New York. In a dramatic, high-stakes legal showdown, a federal judge has just delivered a blistering interrogation of former President Donald Trump's legal team, placing his historic 34 felony conviction directly on the chopping block. This isn't just another court date. This is a pivotal battle that could redefine presidential immunity, reshape the 2026 political landscape, and determine the legal legacy of the 45th and 47th President of the United States. The date was February 4, 2026. The venue, a Manhattan federal courtroom. The mission for Trump as attorneys, to execute a legal Hail Mary and permanently erase his conviction. The outcome, a judicial grilling that laid bare the monumental stakes. To understand the sheer gravity of this hearing, we must rewind. In May of 2024, a New York jury found Donald Trump guilty on 34 felony counts of falsifying business records. The case, prosecuted by Manhattan District Attorney Alvin Bragg, centered on a $130,000 hush money payment to adult film actress Stormy Daniels. In the run-up to the 2016 election, the prosecution successfully argued that Trump illegally disguised subsequent reimbursements to his former lawyer and fixer, Michael Cohen, labeling them as legal expenses in his company's ledgers. While the presiding judge, Juan Merchan, ultimately sentenced Trump to an unconditional discharge, meaning no jail time or probation, the conviction itself stood as a historic, first-of-its-kind legal verdict against a former U.S. president. It was a political and personal cloud that Trump and his team have been determined to dispel ever since. Their strategy hinges on a single, powerful Supreme Court ruling from July 1, 2024. In a landmark decision, the court established the principle of absolute presidential immunity from criminal prosecution for official acts undertaken while in office. Trump's legal arsenal has since been built around this precedent. Their core argument is bold and far-reaching, that the act of orchestrating hush money payments was not a personal endeavor to conceal an alleged affair, but an official act integral to protecting the integrity of the 2016 presidential election. Therefore, they contend it is forever shielded from prosecution. This is a master key they have tried to use twice before to move the case from state to federal court, and twice they have been denied. However, following the Supreme Court's clarification on immunity, the Second Circuit Court of Appeals remanded the case for a fresh judicial review. This set the stage for yesterday's critical hearing, the third and most consequential attempt yet. Presiding over this legal theater was Judge Hellerstein of the Southern District of New York, a veteran jurist appointed by President Jimmy Carter. Judge Hellerstein is known for his sharp intellect and impatient demeanor with legal maneuvering he perceives as frivolous. For over 3 relentless hours, he dominated the proceeding, subjecting Trump's lead attorneys, Todd Blanche and Emil Bove, to a meticulous and often skeptical cross-examination. The Trump team presented a 3-pronged offensive. First, they argued the immunity wall, insisting the payment was a core presidential act tied to electoral security. Second, they demanded a venue switch, asserting federal jurisdiction must now override the state court post-immunity. Third, and most consequentially, they pushed for the total erasure of the conviction, seeking to have all 34 felony counts vacated immediately. Judge Hellerstein's response was a procedural onslaught. His central, repeated point of contention was one of timing and strategy. He aggressively questioned why Trump's team did not seek a federal transfer immediately after the Supreme Court's July 2024 immunity ruling, instead engaging in further state-level litigation. "Why didn't you come straight here?" he pressed, suggesting this delay constituted a critical procedural error that undermined their current position and wasted the court's time. The prosecution, representing the state's interests, countered with a clear, forceful narrative. This was purely personal conduct. They framed Trump at the time of the payment as candidate Trump, not President Trump, arguing that a private transaction to conceal a personal matter could never fall under the umbrella of official presidential duties, regardless of its tangential connection to an election. The most telling exchange, paraphrased from courtroom reports, cut to the philosophical heart of the case. Attorney Blanche, the threat from Stormy Daniels, represented a direct harm to a national election. Taking action to mitigate that harm was therefore an official act. Judge Hellerstein, but you were overseeing an election campaign. You were candidate Trump, not President Trump. Where is the line? This hearing was not conducted in a vacuum. It represents a single, tense front in a vast legal war engulfing the Trump administration. The current Supreme Court term is itself a docket of destiny, featuring 3 blockbuster cases that directly challenge the scope of Trump's executive power. The Liberation Tariffs case, argued February 2026. This challenges the constitutionality of the massive unilateral import taxes imposed by Trump. Early questioning suggests that justices are highly skeptical of granting a president essentially unlimited power to wage trade wars without congressional oversight. With hundreds of billions in economic impact at stake, the Federal Reserve case argued January 2026. This case poses a foundational question about the independence of America's central bank. Can a president directly fire the chair of the Federal Reserve? The ruling will determine the balance between political authority and financial stability. The birthright citizenship case scheduled for April 2026. This seeks to overturn a century and a half of legal interpretation by challenging the guarantee of automatic citizenship to anyone born on U.S. soil as outlined in the 14th Amendment. Beyond these zenith cases, the administration is battling a litigation tsunami of over 600 active lawsuits and unprecedented pace. While plaintiffs have secured early victories in a significant number, often against executive orders, the Supreme Court's immunity ruling has effectively created a new legal reality, a two-tier system of accountability. Official acts are now considered bulletproof, permanently insulated from legal challenge. Unofficial acts, however, remain fully exposed. This dichotomy is a new battlefield, and the hush money hearing is its most prominent current test. Judge Hellerstein's imminent ruling will therefore answer a question with profound implications. Does a constitutional shield of presidential immunity extend to cover what a district attorney successfully argued was a fraudulent, personal business transaction? A decision in Trump's favor would represent a staggering expansion of that immunity, potentially nullifying state-level convictions and setting a precedent that would resonate for generations. A decision against him would reaffirm the power of state jurisdictions to hold even the most powerful individuals accountable for actions deemed outside their official capacity. This is more than a legal brief. It is a defining moment for the principle of equal justice under law. The courtroom drama may have paused, but the nation now waits, knowing that the verdict will chart a course not just for one man, but for the presidency itself.